you speak up? We can't hear you.
There was a motion and a second that, based on Mr. Malcolm's statement that he hasn't even discussed the matter with the employee, that we didn't feel there'd be a conflict of interest. The motion was made and seconded, and the four of us voted that we didn't feel he needed to recuse himself. If you can't hear, just tell us, because there's some noise.
Can you tell us who the employee is?
The employee is Danielle Bass. Okay. So.
Can I ask a question?
Yes, sure.
David Steinmetz is an alternate. Did he vote on that? Is he voting?
Actually, he can vote tonight because we have 5 members and.
So yeah, both of them are voting tonight.
Okay, I just wanted to make sure.
Thank you. Okay, because this is a completeness review, I just want to make sure the board is on board as to any public comment tonight, whether we're going to hear public comment, as this is a completeness review and not necessarily hearing the actual variance request. So I'd like to open that up, that discussion, before we go any further.
Well, I would suggest that under the rules that we're governed by, a completeness review is not an open hearing. It's preliminary, that for one purpose and one purpose only, and that's to decide whether the application is complete in and of itself, so that the hearing can take place on a complete application. So not only do I think that we're not able to take it, I think it would be improper to do so. Unfortunately, I know there was a letter to the editor that suggested everybody came here to discuss it tonight, but as the notice clearly stated in the paper, it's a completeness review only. And I believe very clearly that our hands are tied here. We cannot have this in open hearing or public comment, and I don't think we should, for the reasons I stated.
Anybody else comment?
We need to make sure that the application is complete. I know there's a variety of opinions out there that probably need to be heard at some point in time. I don't know if it's at this session or not. Nor have I looked at the specifics of what states that it's not a public.
It's very short. But, and I think the purpose for that is because people do have opinions. If there is an incomplete application and it gets amended, there's something else to discuss, which if there isn't, then we don't have it. So our goal here tonight is to determine whether or not there's information that is missing in the application. We either tell them it's complete and schedule a hearing, or we tell them it's incomplete and we schedule a hearing subject to them bringing additional information back, all of which will be published in the newspaper for those of you who want to voice your opinion, to know the complete story on which you're basing your opinion. I think our purpose here is to make sure that the public and we have a complete application before we take any formal hearing on it.
Initially.
Martin, you have any opinion on this? No. Anyway. So, as such, why don't we, has everybody read the application? And why don't we go down through criteria, not criteria, but what constitutes a complete application, and we'll go from there.
Can we, this whole section down here on what has to be done for the application can come to us, we have the town just.
Oh, yeah, that's what I was gonna, yeah, I was gonna
Jim?
Yes, sir.
The preliminary requirement before it even gets to us is set forth in section 5.4.2 as sequence. Can you verify that all of those issues dealing with taxes and outstanding violations being met that are satisfied, so rather than going through each and every one of them?
Sure.
Okay. So let the record show that the town is certified at 5.4.2 through and including 5.4.2.4 are all satisfactory, or have been satisfied so that the application is properly before us. Thank you.
Okay. I guess next is whether we as a board have any opinions relative to the application in front of us. Again, in its entirety, whether it's complete and satisfies our own objectives here.
I had a few issues that I thought would help it from my standpoint.
Okay.
Who am I addressing? Is it yourself?
Yes, my name is John Springer. I'm the attorney who represents the applicant, Aaron Tower.
Mr. Springer, in paragraph 3 of the application, you identify the size of the area being developed. But I see nothing in here that gives us total size of the property. Could you provide that so that we have a relationship of what is being developed to this total size of the property?
We can do that. If I may, we submitted site plans separate and apart. What I had submitted, to take one step back, I went online, I didn't find the application form per se, so I just did a petition. Lori Colton emailed me and said we needed to fill out the form as well, which I did. And when we submitted the form, which was a week or two after the first petition, we also submitted site plans, which give the size of the property. I have extra copies if you need them. It's 5 point, well, actually, that's.
Do we have a copy of the site plan?
I sent 7 or 8 copies in. Yep, that's it.
Okay. Well, if you will, since we go through this section by section, when we're determining whether the variance is granted, could you just insert in item 3 the total square footage of the lot? It looks like it's a fairly sizable lot.
Yep.
So we have a numerator and denominator in that section 3.
Yep.
It's not in here, but the question in my mind came up, are there any alternatives that would allow you to do this other than this 120-foot modifying power?
We are prepared to talk about that issue at the hearing.
Okay, thank you. In paragraph 8, you deal with the significant area of inadequate unreliable coverage which constitutes a significant gap. Would it be possible in there to identify in some way the, I guess, for lack of a better word, the boundaries of the gap relative to the area that's being impacted in this residential district?
We can, and again, I don't mean to testify. We submitted RF plots with the application that show the gap, but we can certainly bring to the hearing additional documentation of further.
Actually, what I'd just like to have is these sections modified to reflect whatever you're relating to in these paragraphs themselves, so that when we go through it.
Okay.
So, for example, on the first one I asked for, if you give the square footage there, and you've given us the square footage of development, you've got a fraction that's easily determined just by the paragraph itself.
Okay.
And the gap, if it's related to the area of the residential area that's being impacted, how much is going to be covered, how much isn't going to be covered.
That is shown by the plots we submitted. I feel like, and
Okay.
we talk about that in a little more detail in 20, paragraph 20 about the radio frequency plots. We have Darrell Wilson, an RF engineer here, when we do the hearing.
Okay.
We can address that, but I think that information has been provided.
Okay. you have gone through the elements as you read them of the tests, the 7 tests that are necessary to satisfy with regard to the variance. But there's a section that hasn't been responded to at the end of that, which is section 5.6.7, and specifically 5.6.7.2. Would you be kind enough to add into this your specific response as you did with all the other sections to those 2 sections, please? It's at the very end of our ordinance.
5.6.7.2.
Limitations and 5.6.7.2 under that section.
Okay, I thought,
I didn't see it referred to anywhere.
well, I thought we covered that.
Well, just check it.
Okay.
If you would add that, then
Yeah.
I think we would have a complete application, but as it is, with the exception of those 2, I don't believe it is complete without the additional. That would be my motion.
All right, there's a motion on the table, the application is not complete. As per Scott's comment, I don't know, that's Scott, I don't know if anybody else has some comments.
I guess I'd like to take a look at what the tower actually looks like. I see we have some sort of an artist rendition of it in this form here. Is there any pictures, any actual standing tower that this thing looks like?
That was one of my other shit, I thought I'd comment in here. Yeah,
I'd like to see
an actual
what it
picture.
is in the application, to have it complete. I don't want to go on an artist rendition. I want to see what it actually looks like. If there's one standing someplace, whether it's here or elsewhere. I also would like to know what the type of vegetation is on the property.
I'm sorry, could I,
Go ahead.
we can get I'm sure we can get photos of the actual monopine. And then, I'm sorry, I missed the first part of your next comment.
I'd also like to know what the height of the vegetation is on the existing property and the surrounding property that this is going to be housed on. If you're 120 feet up, what's the existing vegetation in that area?
All right.
Well, I worked on a couple of these years ago in the area, and they always had the size of the property had to be, so if the tower did fall, it had to land on that piece of property. And I see that if it's 120 feet, chances are if it does fall, it's not gonna fall within that 100 square feet. And it was only done basically for a safety factor, that it wouldn't fall on anybody else or on anybody else. And I understand that that piece of property is leased at 100 feet, but that doesn't mean that somebody else can't encroach on that structure and be in a danger zone.
Well, if we get the size of the property, what I've asked for and the placement of this development relative to the property itself, we would be able to determine that.
It's 100 by 100.
Yeah,
I understand.
Right, but where is it? Is it right smack in the middle?
Yes.
It's on that.
It
I
is.
assume. There's a diagram here if you want.
Yeah, he's
Well, see, I think we submitted 2 packets.
Yep.
One, the packet with the actual application form in front, should have the site plan
So,
attached.
there it is located on the actual line. All right. So actually it is there, and they've done it. And so, I think that's this point, and you're giving them some.
If down the road, that tower is sold, and that lease is maintained on that 100 by 100, anybody can build within that distance. We have one now that is over here on the back road, and I don't know, but that's 30 by 30, and the tower at the time was over 100 foot. It's landlocked. It's kind of, I don't even think taxes have been paid on it. The piece that was gonna go to, out to bid.
Well, again, I think this will come up in the actual hearing, but it's good point.
We can address that.
If you, yeah, that would be great.
Mr. Chairman, if I might add, as you all know, this application is in part governed by the Booth Bay zoning ordinance, but in part by the Federal Telecommunications Act. And one of the issues under the Federal Telecommunications Act is that municipalities have to make sure that they're not regulating the tower in such a way, or the proposed tower, that the ordinance is being applied in such a way as to prohibit or have the effect of prohibiting the provision of personal wireless services. And so basically the applicant's going to need to show to you that there's the need for this tower. And technically, and that really gets into a technical analysis of whether or not, there's a technical need for this tower. And so typically, when these applications come through, the municipality asks for a peer review to be done of the application. And typically, the applicant pays for that peer review as well. And so we have done these sorts of applications before, and we contacted what's called an RF engineer, a radio frequency engineer, just like what Mr. Wilson is. And we got one of the RF engineers' take on what the board might want to ask for if it's going to ask for peer review, and that's stated out an email which lists 5 items that are, if you were going to have a peer review done, that's what the town's consulting engineer would want to look at. And then it also has submitted out a letter from IDK Communications just setting forth a proposal for what that peer review would involve. So I just put that out there. I think as far as the completeness review goes, if you're going to require a peer review of this application, you ought to ask for those 5 items.
Mr. Chairman, if I may, with all due respect to Ms. Daggett, I do not believe this Board of Appeals has the power to ask for this. Our hands are tied by our own ordinance. This is not a de novo review. We have no power whatsoever in a variance appeal to do anything but, as you correctly address the provisions of 5.6. That's frustrating to some degree, but that's not what this board does. That's what the planning board does. And I don't disagree that the type of consideration that Ms. Daggett was suggesting would be helpful. It would not, in my opinion, be helpful to this board because we would have no right under the powers we're given by our own ordinance to consider it. Now, since it's been brought up, my suggestion would be that your client think very seriously of voluntarily, what's the word I'm looking for? Revoking this application, taking it off the table and reapply to the planning board. They do have the power to have a completeness review of their own, to hear anything and everything that's outside that they think is relevant to this. We do not have that power. And I certainly don't think we have any powers to negotiate with you as to what you're willing to pay for or not. The town has that. Just like the town can go ahead and change the ordinance if they thought this was a good thing for that residential district and your problems would be solved. But I respectfully suggest that our Board of Appeals powers have been very limited from the get-go to what we can do under this ordinance, and that is to accept your application subject to our completeness review, given the facts that you want us to see if they meet these 7 tests, all of them. and if they don't, again, as you correctly point out, meet all of them, then we cannot grant the ordinance by law. But we certainly do not have, in my opinion, any power to negotiate or even ask for any additional input from a professional, because you're submitting the application. Now, if you agree to that outside of this room, then you could amend your application, but it's not something that we have the power or even should get involved in doing.
So I'd like to ask a question of, why has this actually been in front of us if we don't have the power to hear this then? Okay, it's a logical question.
With all due respect, I think the Board of Appeals absolutely has the authority to ask for a peer review. If you want to quibble about who pays for it, that's fine, but the Board of Appeals absolutely, and I think the Board of Appeals absolutely wants to have a peer review done of this application.
I don't disagree with that. Actually, my question is more, why is this application actually in front of us versus the planning board
Okay.
then? So just be clear with the.
Yes, I will explain that. The property is located in the special residential zoning district, and in the special residential zoning district, telecommunications towers are a prohibited use.
Yep.
So the applicant is here before you today seeking a use variance. And if the use variance is granted, I mean, you have the authority to put a bunch of conditions on the variance. Mr. Page is concerned about a fall zone, all of that. You have the authority to do that, because this won't be going to the planning board. If the use variance is granted, you are in effect the permitting authority, because the way your ordinance is written, that telecommunication towers are prohibited in the SR zoning district. The applicant makes its pitch that it's entitled to a use variance. And this isn't just a matter of the Booth Bay zoning ordinance. It's also the interplay between the Booth Bay zoning ordinance and the Federal Telecommunications Act. And that's why I think, for purposes of the Federal Telecommunications Act, you absolutely want to have a peer review done. Because if you say no to this tower, and there isn't evidence in the record that shows that you're justified in saying no to the tower, then I can pretty much guarantee that the applicant will be going to federal court. That's what.
So you show me in this review criteria, where we have the right to consider if it's in violation of our ordinance, the way the ordinance is written, where we have the right to consider something from the FCC or anything else to overturn our ordinance. Now, the selectmen have the right to change the ordinance, but our hands are tied here. There's nothing that says that we can not issue a variance if it's in violation of this ordinance.
Because the Federal Telecommunications Act will, in some instances, trump your ordinance.
But it's not, we are not given anywhere in here to consider anything outside of the ordinance. We're not. The planning board has that right.
Sure you are. Under the Federal Telecommunications Act, you need to know whether your action is going to have the effect of prohibiting or having the effect of prohibiting personal wireless telecommunications services. And if the applicant makes the showing that this tower is really needed, then they're going to be entitled to their use variance. And you need to know if the technical data is there to support their showing that this tower is really
Then
needed.
the town can present that as a part of its case to the appeals board.
The town isn't, I don't know what you mean by the town.
They have the right to submit the application that they want to. Now, if you feel that you want that peer review, do it. But we don't have the right, in my opinion, to require it of them because it's their application.
But why is that, why wouldn't we, Scott?
Because we don't need it to make this decision.
We don't need it to make the decision in terms of completeness review.
The variance. We don't need it to make that decision in the variance.
Well, but I guess I'd like to know more about the Telecommunications Act, because I don't want to, what I don't want to do is, I don't want this board
Then
to
let's have.
stumble on, hang on. I don't want this board to stumble and then have it go directly to federal court and cost the town more money. I'd like to have a pretty solid hearing so that we don't, I don't want to make sure we follow the rules. And that's why we've asked Ms. Daggett to be here, because I want to be as complete and thorough as possible, so we don't just automatically go to federal court.
I think
It
we
costs the town a lot
I
of
think
money.
we have to recognize that if the town of Booth Bay wants this to go through, or doesn't want it to go through, they should let us know their position on this. Now, if we require, as a part of this completeness review, that this other review be done, that's his choice to do or not to do.
Just to be clear, this peer review would be on behalf of the Town of Bouquet Board of Appeals.
It's not them, it's
It's
us.
not, a review for the applicant. It is to have somebody on the Board of Appeals side of the equation taking a look at the applicant's data and determining whether that data, supports their application.
If it doesn't support the application, we don't need a peer review, correct?
How are we going to know that if we don't have the peer review?
We can judge it on its face. They're making their best argument forward here on their face. If
Are
we
you
don't-
an RF engineer? I mean, this gets very technical very quickly. I don't know that,
Yes,
you
but
board members can
the
make that
provisions
determination.
of this is very clear. Does it violate the ordinance? Yes, it does, unless they can prove it doesn't. Is there undue hardship? That's a question. Is there or isn't? And these tests are identified. If it doesn't meet all of those, we have no option but to turn the variance down.
The applicant may be entitled to a variance under the Federal Telecommunications Act standards.
Then let them tell us why they would be. Good suggestion. You need to complete then and tell us why you would be, if you think you would be, under the Federal Communications Act if we turn this variance down.
And we're prepared to do that in the
You
hearing.
know they're gonna do that
If-
10 ways to Sunday.
They haven't done it
They
yet.
haven't,
They haven't
there's
done it
a
yet.
good start.
I think we have. We haven't even heard on it. We've submitted the evidence. You can't say we haven't done it yet. We haven't done our hearing. For the record, I agree with 100% with Attorney Daggett says. I mean, reasonable minds can differ, but this is what we do.
Then let's ask them to submit it as part of the application.
It can't be that can't be an acceptance criteria.
No.
No, you can't. It's an independent study.
These are the items, just so you can hear what, and Ivan Pegasic of IDT Communications is the proposed peer reviewer. And these are the items that he would want to see in order to make your application complete, so that he could then perform a peer review. Item number 1, and I'll give you a copy of this, but I'll read it so everybody in the audience can hear it as well.
Thank you.
Item number 1, coordinates of the proposed site along with any existing or planned AT&T radio sites within 7 miles of the proposed location. Item number 2, transmit ERPs for every site identified in number 1 above. Item number 3, antenna height, azimuth, down tilt, and model number for each site identified in item number 1 above. Item number 4, received signal strength levels for on-street, in-vehicle, and in-building. Item number 5, location and coordinates of radio sites surveyed but not selected by AT&T.
So,
Well, some of this we've already submitted in the RF material. Some of it we could testify to at the hearing. If the board wishes to say that these are required to make our application complete, I'm not going to argue with you about it. I don't think that's really correct legally, but if you're going to farm it out to a consultant, he's going to need 30 days anyway. So, I'm not going to argue that point of view, if you understand what I'm saying. I think, if I may, in fairness to us, because, as I said, some of this stuff is there and we can testify to it. If you're saying the application's incomplete because we have to supply this, we'll be happy to supply it, but I don't want to lose 30 days. So because can we have Mr. Wilson or someone provide this directly to your consultant with the CC of the board?
Well, there's some other information as well that the board, is looking for, not just this. So my sense is, you tell us how quickly you can get it to us, and, the board will have to meet again and decide whether all of these
That's not trying to
applications.
avoid,
Well,
because I think,
they're not going to determine, I don't think, based on
I
what the
understand.
board members have said, I don't think they're going to determine it's complete tonight. And just so the board members understand, once you make a determination that the application is complete, the 150-day time period for your review of it starts to run.
I understand.
I mean, this will, I'm sorry,
No, go ahead.
this will not take long to produce. Nor I don't think will the other items, but.
But I
You can
want
tell us when you think you can get everybody, the board the information. I'm sure they don't have a regular meeting date. I'm sure they'll schedule a meeting, shortly thereafter.
Oh, okay.
we don't-
So-
yeah.
I would say a week. Is that, Daryl, is that?
I can give you that tomorrow.
Yeah, I mean, I'm gonna say a week.
But I thought we, or the town, wants to have our own peer review, right? Are we talking about hiring our own peer review here?
Right.
So it's not them supplying, they can supply what they're gonna do, but we still need to do our side of it to make sure that what we're hearing is correct.
And how long does this take?
I think.
Well, then you're back to that. But I think we should-
Yeah, but that's not an issue of completeness.
Right.
That's not an issue.
Right.
Right, okay, yeah.
No, I'm just.
I'm asking the question, how long does this review take, this independent review take?
I don't think it takes more than 30 days.
What would you estimate it?
I would estimate between 30 and 60 days, depending, I mean, it's gonna depend on how busy he is.
Right.
But if he's not real busy, I would certainly say 30 days. I mean,
I think he's relatively, so I'd say probably in the 60-day range, just
Yeah,
to be safe.
just to be safe, yeah.
And one of a completeness review of the application, does this need to be part and parcel of that?
That's just a proposal for what the
I
peer review
understand.
involves, just so you can see what it involves. It's really the 5 items on this sheet that are part of the completeness review.
So it seems to me that we have a number of items that Mr. Adams has put forth, plus this particular email on the actual
Well, there's one other,
Communications Act. So I want to make sure that as we go through this, we understand exactly what we're asking for, and then we'll vote on that. All right, and so that everybody understands, and then decide when we're going
well, there's one other thing, since it's now, we're being told that there's an FCC rule that can override the town ordinance. I'd like to see somebody give me that in writing, show me where that FCC rule is that says if we are trying to protect a residential district, which is what this comes down to, that may not have all the cell phone coverage that AT&T has, that we as a town have a responsibility to throw it down their throat in spite of our own ordinance. Now, you haven't mentioned, the only place I saw mention the FCC was in, is Mr. Chew's or Chow's? Is that the proper name? In his summary, where he mentions that. But if it's being suggested that there's a federal law out there that doesn't allow us to protect our town the way we want to protect it vis-a-vis our ordinance, then we're going to need to know that. Because whether I think that we have the right to consider it or not, it should be stipulated.
I was going to say, that's part and parcel of why I wanted Ms. Daggett to weigh in on the Federal Communication Act. I am not a lawyer, I don't understand a lot of this stuff. I want to make sure that we as a board understand what our rights are and what the Telecommunication Act trumps us on. And
That can either come from the town or from the applicant.
that it can.
But it needs to be in writing and
You
specific.
you do want to.
Absolutely, I want to see the wording of the law.
I have to agree with him because, I mean, what it sounds like to me, and correct me if I'm wrong, but no matter what we say, the FCC can override it and do it
I
anyway.
believe that's the case.
Is
Not
that?
no matter what
No,
you say,
no.
the applicant has to make a certain showing of the need for this tower.
Yeah,
okay.
And that becomes a very technical discussion. The applicant has its RF engineer. What I'm suggesting is you want to maybe double check the applicant's numbers by hiring your own peer reviewer engineer.
Even if the RF engineer proves his point that they have to do it here, and we have an ordinance that says you can't do it here, it's a residential district. Is anyone suggesting that the FCC says regardless of what district it's in, you got to put a tower there? And if it is, I want to see that in writing.
I'll supply law. I mean,
It is here, it is.
It's in, the statute is mentioned in my letter to the board dated October 10th, and if you'd like the citation, it's 47 USC.
No, I'd like a letter of opinion to the town, to us, from the town's legal counsel, stipulating why we have to make that decision,
Certainly.
not something horrible.
Well, it's mentioned in my letter, but I'm pleased to flesh the issue out some more for everyone.
Thank you.
If that tower wasn't located down there, what would be the next closest piece of property that something like that could be put on that would?
Well, I'd rather not get into that.
Yeah, I mean, if we're not gonna be able to be heard tonight, I don't want
That starts to open up the whole
Yeah.
hearing, Martin, so right now, we're really just considering whether this application is complete or not. And that's really how this whole conversation is going to work,
So we have.
so I'd rather not get into that.
Well,
That will certainly
I
come up in the
understand,
hearing, you know,
But if I have a piece of property here and you have a piece of property there, and both signals can turn around and meet what you want,
Yeah,
and this one's in a legal piece of
right.
town, and this one's in an illegal piece of property,
Yeah, I hear you.
where
I
do you?
I think that's,
I'm with him.
yeah, well, I think
That's for the
Wait,
discussion. That's for the discussion.
Who's with who? We haven't had a word
Yeah.
yet of our presentation. I'm
That's-
not getting,
that's what
well,
the
if I may
discussion
be heard, Chair,
Oh, you're
Mr. Chair, we're being told we can't speak, and yet I'm hearing people forming opinions here already, and I have to tell you, I'm a little put back by that. If we're gonna talk about this, let us present our case.
I agree, I
I mean, you
think, I agree with you.
Thank you.
Okay, I agree with you, and that's what I'm telling Mr. Page here, that I think that it's a good question, but that's a question that will happen in the hearing, or should be brought up at the hearing, and not here, and not in a completeness review. I want to be very specific that this is a completeness review hearing and not the actual hearing for the variance, okay? They're two very different hearings, okay? So I think some of that will be addressed
Oh,
when they
absolutely.
make their presentation, and I think it is definitely part of why we need some expert opinion on the Telecommunications Act. So I applaud you for bringing it up and thinking about it, but I think that it's not part of tonight's.
So let's sum up what we want to have.
Yeah, I think we should do a summation, and
Item 3, relationship of square footage of property to developable area, and an actual picture of one of these monoplines. In paragraph 8, some reference to the coverage that is and isn't, and you said that was a...
I can sharpen that up.
Yeah,
Yep.
and that's in paragraph 8.
8. And then at the end, the specific response to 5.6.7 and 5.6.7.2.
And then I think, I'm not sure what the best way to word this is, but the peer review that we would, what kind of a petition do we
Just
want?
those 5 items.
We want, yeah, I guess, so how should that be worded?
The 5 items identified in the IPK communications email.
Oh, okay, we can use that,
Yep,
we can
yep,
use this
absolutely.
email, okay, I didn't know this was good, okay.
And add to that.
And you have a copy of that?
I do.
Yes, okay.
And I would add to that specific aspects of the FCC law that would override our ordinance.
I'll be happy to
Provide that, okay, great.
So
So, do you want to entertain a motion? At which time we'll have some more discussion? Or do you want to still just have regular discussion?
I make a motion that those are the elements to complete the application that is incomplete at the current time. And we can schedule a hearing subject to getting this packet, whatever time frame we want to at this point.
Yeah, I guess other questions that I have should be in the hearing themselves, so yeah, I second that.
You second that? There's a motion on the table, there's a second, any discussion? There being none, all in favor? So moved.
If I may,
Yes.
if we submit this within a week, you then schedule a hearing, you don't meet every 30 days, you meet as needed?
That is correct.
Okay, and
I
I,
would just need to satisfy the
Notice
legal
requirement,
notice. Yes.
can I communicate directly with Lori Colton about it? Because I have other people I need to bring, so I
Sure.
assume it's okay if I coordinate with her, just when I submit it saying that.
Go
these are-
ahead.
these
Does
are
the
dates.
board want to meet again, just to make sure the application is complete?
Well,
And
I
then
would-
at that point, schedule the hearing.
Well, that,
That might be why.
I think there's enough, I think there's enough here. if we-
you want to do it in
if
2
we
meetings then?
Well, because you're also going to need to have your peer review done, because I don't think you're going to have your public hearing until the peer review is complete. See what I'm saying?
Yeah.
So
Okay.
perhaps in
So-
2 weeks, you meet again for another brief meeting on whether the application is complete. Once you make that determination that the application is complete, then the 150-day time period starts to run. But if it's going to be 30 or 60 days before you have your peer review, you may be looking at, scheduling the public hearing in 90 days. 45 or whatever.
So we would not start any peer review activity until we deem this complete.
Correct.
Yeah.
Well, because
Because we
we
still
don't
have
have the
150
information.
days.
We don't have the information.
Right, true. Okay.
So for the next
So-
hearing, I'm not bringing Mr.
You
Wilson.
don't need to do that, right? We will
Okay.
do, hopefully it'll be a very brief meeting, and I will determine whether the application is complete, at which time then we will try to schedule a subsequent meeting on the action here.
Do you want to discuss if the applicant's saying they can get the information within a week, you
Yeah,
probably want
I
to
do.
have a week to look at it.
Yeah, I think within 2 weeks, but I don't know in terms of the public notification requirements
I
with
think you
paper.
can pick a date tonight, and I guess as long as, then it could be in the newspaper.
Well, this is, we know if we have it set tonight, it's continuation. of-
Well, I
I don't think we have to do that.
Do we actually do?
Not
I
to
think
say
to
that
be
the
safe, you
actual
have a
hearing
second.
is-
You need another newspaper notice, but it is a continuation of tonight.
Right, okay. So we could legally hear that in 2 weeks then.
Correct.
So, how's everybody, 2 weeks from today,
That's the 19th.
19th? So I'm not sure.
That's 19th, it's a Tuesday.
I don't know, are Tuesdays good for everybody?
Nice Tuesday.
The space is
We're missing
available.
NCI.
Excuse me?
The space is available.
Okay, Tuesday.
Is that okay with your?
Sure.
Your team?
7 o'clock? Well, it's just gonna be me.
Just, what team? Okay, Tuesday.
Tuesday at 7?
Yep. Okay, any more discussion from the board? If there be none, I'll entertain a motion to adjourn. Any discussion? All in favor? So moved. Meeting's adjourned. Thank you all.